Hi there, my name's Leja. I'm a real-life lawyer and I'm on a mission to demystify the law and how it affects your everyday life. Today I want to talk to you about a little law that you've probably never heard of, but absolutely affects your everyday life. It's called CDA 230. That's the Communications Decency Act Section 230. And before you leave, because I know that sounds boring as hell, what if I told you that the story of CDA 230 includes such figures as Jordan Belfort, the Wolf of Wall Street? It also includes issues of sex worker rights. And it's a law that has allowed for the proliferation of the internet as you know it today. Sound interesting? Well, stick around. Before we get into anything though, I would like to offer the following disclaimer, and that's that I'm a lawyer, but I'm not your lawyer, and nothing that I say should be construed as legal advice. You should always seek the advice of a licensed attorney before making any legal decisions. With that, let's get into it. Okay, so the background. Just picture it. You're in the 90s. Maybe you weren't even alive yet in the 90s. I was just a baby. Maybe you're just a child in the 90s. Maybe you're a teen. Maybe you're a boomer who somehow found YouTube and like, hello and welcome to the internet. I'm happy that you're here. Picture the 90s, you know? The internet is brand new. All it is just like a bunch of chat rooms and some forums and a bunch of nerds emailing each other.
Now, Julian, I see you have your computer linked to the telephone line. Can you tell us how you did that?
Yes, well, it's very simple, really.
You have to use an entire phone line in order to get onto the internet, and that dial-up sound is in everyone's home. Are you present? Are you in it? Are you in the 90s? Good. So it's 1996. So this was like the dawn of the internet age. People were very concerned about laws and regulations that would hamper the growth of the internet because they saw it as this really promising thing, which it was. And so people had great fears about any sort of regulations that would curb free speech and therefore curb the development of the internet. And that fear came to fruition with the case called Stratton Oakmont v. Prodigy. The company called Stratton Oakmont might ring a bell for you. If you've ever watched the Leonardo DiCaprio classic Wolf of Wall Street, Jordan Belfort founded Stratton Oakmont. In 1996, they were the plaintiffs, meaning they brought the case against this online website called Prodigy. Prodigy hosted a number of forums. One of those forums was called Money Talk, and it's where people posted different things about the financial industry. One person went online, logged in, pulled up the forum, and decided to write a post about how Stratton Oakmont was committing fraud. So you know what they did at Stratton Oakmont? They sued Prodigy, the host of this forum, for libel, saying that this forum was a publisher of this libelous statement that this person logged in and wrote, and that they should be held accountable for what this third party said. And the court found in favor of Stratton Oakmont, saying that Prodigy as a publisher had an obligation to filter the posts that are being posted on their website and could be held liable for libel. This, along with a lot of other developments in just the internet age, created an impetus for Congress to pass a law, the only part of which that is relevant today is called CDA 230. This happened in 1996. 3 years later, in 1999, Jordan Belfort would be convicted of criminal fraud, which is exactly what he was being accused of in this Prodigy lawsuit. So basically people were concerned about free speech being curbed on the internet if these big service providers were going to be held liable for the things that people were logging in and posting. And so CDA 230 was born. CDA 230 says in relevant part, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Meaning intermediaries like Facebook, for example, or any other websites that allow third parties to post onto it will not be considered the publisher of that third party content and therefore will not be held liable for it. So like if, say, the Russians start posting inaccurate things on Facebook, good old Zuck is free and clear of any sort of liability for that. Or say if you're Pornhub and someone logs in and posts revenge porn on your platform and someone else comes along and is like, oh, that's a video of me that I did not consent to be posted on the internet, you're free and clear if you're Pornhub. And so it allowed for all these providers, all these internet websites to proliferate and grow because they didn't have to be stymied by lawsuits from other people saying that the content being posted on their websites was violating their rights or their law or hurting them in any way. These big websites just didn't have to be responsible for that. And so this was 96, and in the years after CDA 230 was passed, a number of lawsuits came along doing just that, trying to hold websites accountable for the horrible things happening on their sites. Time and time again, judges ruled in favor of these websites because judges were basically finding that CDA 230 created this like airtight protection around websites that they could not be held liable for the things that other people were posting. This, however, really pissed off an extremely influential group of voters and organizers. traffickers. Moms. Moms were pissed. Why? Because of sex trafficking. They were seeing that these websites were being able to be used by sex traffickers to proliferate a sex trafficking industry, and these websites couldn't be held responsible for it because of CDA 230. So they organized and they pushed, and there was this huge campaign and a bunch of momentum pushing to overhaul CDA 230 so that websites could finally be held liable for the things, the awful things that people were doing on them. And then all of that momentum finally came together, and you had what was known as FOSTA or SESTA. So FOSTA was Fight Online Sex Trafficking Act in the House, and SESTA was the Stop Enabling Sex Traffickers Act in the Senate. And the two came together, FOSTA-SESTA, it was passed. Trump signed it into law in 2017, and pretty much since then we've all kind of seen over and over again that it didn't really do anything. But here's what it says. Whoever owns, manages, or operates an interactive computer service with the intent to promote or facilitate the prostitution of another person shall be fined under this title, imprisoned for not more than 10 years, or both. So basically any website that allows for user-created content to be posted and it allows for the proliferation of sex trafficking, then that means that that website can be held liable for that activity of those third parties. However, this law conflates sex work, prostitution, with sex trafficking, which is a really common theme in our laws and in our entire judicial system and in our entire society. This idea that sex trafficking and prostitution or sex work being something that is a consensual act between adults, versus sex trafficking, which is non-consensual and often deals with children and minors. Our lawmakers just kind of overlap those two, and in this law that led to some pretty dire consequences, because not only were websites being held liable for the sex trafficking victims on their sites, but they were also going to be held liable for sex workers that could get kind of swept in with all of that category. It also meant that websites that were smaller, that hosted personals pages where a lot of this sex trafficking was occurring, didn't have the infrastructure or the money to start monitoring all the posts to weed out the sex trafficking victims, and so they had to just shut down entirely. Specifically, a website called Backpage as well as the Craigslist personals both shut down immediately after FOSTA-SESTA was passed. This was because they did not have the infrastructure to do the monitoring that was required so as not to be held liable under this new law. The problem with this, though, is that Backpage and Craigslist allowed for sex workers to safely find clients in a way that allowed them to screen clients and to be safe and do background checks and have more control over their situation. And the result of these websites being shut down meant that a lot of sex workers had to look to different means to find work, some of whom, the most vulnerable sex workers, had to go out onto the streets to find sex work. And this led to a number of reports of sex workers dying and going missing. And reports since the passage of FOSTA-SESTA have shown that this law did nothing to curb the sex trafficking, because sex trafficking has been happening for eons and eons, and pushing it back underground by shutting down all the websites that it operates on doesn't really do much to actually curb the problem. Sex trafficking is an awful thing, and the internet helps it to proliferate. I am not denying that. I'm just saying that CDA 230 and FOSTA-SESTA, as it is written and as it is functioning, is not doing what its supporters wanted it to do. So this was a few years ago. The latest attempt to overhaul CDA 230 is what's known as the Earn It Act. So there are a million different opinions about the Earn It Act and people coming from different angles for CDA 230 generally. So I don't pretend to say that one side is better than the other side, or that I necessarily feel 100% in favor of any of these different sides, because it's such a complex issue, but let me break it down for you. So you have concerned citizens who have a very valid concern about sex trafficking and see CDA 230 as a means of allowing for websites to get away with allowing sex trafficking to occur. And they're seeing that SESTA, FOSTA didn't do what they meant it to do, and so they need a new act to curb CDA 230 even further, to hold people responsible for child sexual exploitation. However, I will note that CDA 230 does not bar federal criminal charges against people. It does not protect from that. So theoretically, websites could be held liable under a criminal theory. However, it is a lot more difficult to find a perpetrator and prove that they committed a crime, especially if the perpetrator is a website as opposed to the actual third party posting the harmful content. So then you have lawyers and activists like Carrie Goldberg, who's a fellow Vassar Girl lawyer. Hey, she does a lot of work around CDA 230 and around abuses that are occurring on the internet and they are being allowed to continue to occur because CDA 230 protects these websites. The problem being that a lot of times perpetrators of crimes on the internet, be it doxing or revenge porn or any sort of harassment, anything where they're posting things non-consensually or hacking people, sharing personal information, it can ruin lives. But a lot of times the perpetrators of those crimes aren't identifiable because they're hidden on the internet because they know how to hide their identities, or if their identity is known or suspected because it's maybe an ex-boyfriend, it's really hard to connect that activity on the internet to a person because again, it's really easy to hide your activity on the internet. So being able to hold websites accountable for the awful things that they're allowing to occur on their sites and that they are facilitating through the use of their websites would mean that a lot of victims could get some sort of legal recourse when their actual perpetrators of the violence against them are untouchable in the law, or maybe even just don't have any money so they couldn't sue them for damages anyways, whereas these big companies could be held liable and then actually pay victims for the harms that they're experiencing. So people who are on that side, on the victims' rights side, generally tend to be against CDA 230 because it allows for protections of websites when they know full well that people are abusing their platforms to abuse others. And then you have like tech libertarians like the Electronic Frontier Foundation who are like all free speech or nothing. They're so against any curbs on free speech that they're willing to allow these abuses to proliferate in the name of free speech, which I will note the First Amendment, which protects free speech, does not protect all speech because some speech is not protectable even under the First Amendment. I have videos about that. I'll link above, but it is a little problematic to kind of throw caution to the wind and say like, well, you know what? I'm so afraid that my speech is going to be, curbed that I'm willing to allow other people to get abused just so that I can say whatever the hell I want on the internet. It's an argument I have a hard time with personally. And then you have the law and order types who see CDA 230 as a bar on law enforcement from getting at websites in order to access data that might be helpful in solving crimes. And this is where the Earn It Act really comes in. So the Earn It Act is meant to kind of chip away at CDA 230 as it relates to children and abuses against children, but it also calls for the creation of a backdoor into websites like Facebook and others. There's also the problem that if you create a backdoor into encrypted data for the good guys, the law enforcement to get into, you're also creating a backdoor for the bad guys, the hackers to get into. You can't really differentiate when you create a backdoor who is going to be able to access that door. So it could potentially put people's data even more at risk than it already is. The Earn It Act also does not solve the problem of the proliferation of abuses that are happening on the internet, like doxing and revenge porn, which are only getting worse with this pandemic. CDA 230 leaves them without any sort of recourse, and if they were allowed to actually sue these websites, it could be some impetus for the websites to start monitoring the content that they're facilitating with their sites. And of course this would lead websites like Craigslist and Backpage to shut down, and this could further endanger people like sex workers who depend on the internet for being able to safely, securely, and secretly run their sex work businesses. However, a lot of people argue that having to monitor for abuses on your site should be the cost of doing business these days if you want to run a website that allows for third-party individuals to post things. Yes, CDA 230 allowed for the proliferation of the internet as we know it today. However, it's also allowing for the proliferation of abuses. So is it time to start putting in more controls over these big websites in order to hold them accountable for what they are facilitating on the internet? And a lot of this abuse ruins lives. So there's all sorts of ways to look at this issue, and people are getting hurt on either side of it. So I'm not sitting here saying that I have an answer to this. I wanted to just talk about this law because it feels like no one really knows about it, but it is something that lawmakers and lawyers are starting to talk a lot more about, especially because websites like Facebook are starting to get a lot more scrutiny from regulators. Even as recently as this week, they're being investigated for anti-competitive behavior. People are starting to realize that we've allowed these companies and these websites to grow unchecked to the point where they can just kind of do whatever they want, even against what laws are in place, because they've always kind of been above the law. And CDA 230 played a huge part in the internet and websites being able to operate outside of the confines of the law. Is it time to start regulating them more? Is it time to require websites, if they want to exist, to be monitoring the content? I think there might be a way to do it that in a way that doesn't hurt sex workers, but also allows for victims of abuse to get some sort of recourse from websites. I think if our lawmakers were able to extricate in their minds the idea that sex work and that sex trafficking are not the same thing, and write laws that legislate against sex trafficking while acknowledging that people are using the internet for protection and because they need it to do their jobs, be that sex work or other work, but sex work especially. I mean, I think we have a long way to go before our lawmakers get to a point where sex work is an accepted form of labor that is just like any other type of labor that deserves to have certain types of labor protections involved. That's a whole other issue that I'm not going to get into with this video, and I don't purport to speak for the community at all. I'm just talking about this law specifically that's affecting that community, but I can see a way where we could write a law that could legislate against sex trafficking while not hurting sex workers and allowing for protections for abuse victims on the internet to get some sort of recourse against these websites that are just kind of able to be really flippant with all of the reports of abuse that they're receiving. I don't really have an answer to this. If you have thoughts about what you think should be done, if you are from one of these different camps that I explained and you have something you'd like to say that I didn't properly cover here, comment it down below. I'd love to hear. As it stands, I just don't think there really is a clear answer. But, you know, maybe you think differently. Let me know. If you have any other questions about this or anything else that you want me to answer, please add that to your comment as well. Thank you so much for watching. If you enjoyed this, please give it a thumbs up and hit subscribe if you want to hear more from me. Thanks so much. Have a good day. Goodbye.